Pleasant day, everyone. Welcome to Problems in Criminal Law Procedure and Evidence, or CRI 153. So, I am Rolly Nain. So, good afternoon, Sir Marjun. I was assigned to discuss the rights of the accused. So, we know for a fact that the rights of the accused is one of the highlighted rights the Philippines ever have in order to protect the rights of every individual, most especially the rights of the accused. So, meaning to say, this is being promulgated under the Philippine Constitutions and of course under the Republic Act number 7438, and at the same time it is promulgated under the rules of court. So, moving on, let us have the introductory of my discussion. Fundamentally, due process of law is highly appreciated when it rightfully served to the one who needed the most of its services, with impartiality, fairness, and with a sense of justice. With the government's advocacy on human rights protection, the rights of the accused are undeniably highlighted in all criminal investigation conducted, criminal proceedings up until promulgation of criminal case filed against him or her. So, meaning the rights of the accused should not only be observed during the investigation conducted, but it also observed up until criminal proceedings to promulgation of criminal case. This is in protection of their being for possible excessive power to be exercised by those who are implementing the statutes, most especially police officers who are not observing during the arrest or even during the conduct of the custodial investigation, in which the said rights has been promulgated under the provisions of the Philippine Constitutions as our primary or the mother of all laws the Philippine ever has. So as the protector of their constitutional rights and the parameter to exercise and observe the rights of each and every accused allegedly committed an offense. And now, I will be discussing the transition of the constitutional rights of the accused from the 1935 Philippine Constitutions up to 1973 Philippine Constitutions and finally the 1987 Philippine Constitutions, wherein under these cited constitutions, the rights of the accused were promulgated or even cited so that this will be observed by each and every public officer and or law enforcement officer for that matter when it is they are going to about promulgate the crimes committed by particular individual. Let us tackle first the 1935 Philippine Constitution. So, based on the Article 3 of the Section 17, in all criminal prosecutions, the accused shall be first presumed to be innocent until the contrary is proved and shall enjoy the right to be heard by himself and counsel. The presumption of innocence is a legal principle wherein every person accused of any crime is considered innocent until proven guilty. So, if the prosecution for that matter does not prove the charges true, the accused is acquitted of the charges, okay, or the accused is acquitted of the charges filed against him. So as much as possible, before the person be called as such as the criminal or the one who committed such crime allegedly committed by him, is that he must be first underwent trial, should be heard by the court for that matter, and before the court called particular person as the one who committed the crime, the court must render first the judgment and or promulgate therefore that the person being tried therefore is the one who committed a crime. And of course, shall enjoy the right to be heard by himself and the counsel. Ibig sabihin, the person has the right to be heard by himself to defend himself whatever accusation against him in the court arena and must be presented therefore by the counsel whenever he has a counsel or will be provided thereof by the government. Next to that is that to be informed of the nature and cause of the accusation against him. Uh, it is another protection meant to ensure that the accused receives fair trial. So the person before underwent or going trial is that he must be first informed as to the nature of the crime he has committed, so that at the same time he will be knowledgeable or educated for that matter as to what is going on inside the court arena and what would be the possible course of action that he's going to take, or the possible action that his team or counsel to take on as to the nature and the cause of the accusation against him or filed against him. Okay. And the third one is to have a speedy and public trial based on the provisions of the Republic Act number 8493. So the right to a speedy trial is a human right under which it is asserted that a government prosecutor may not delay the trial of the criminal suspect arbitrarily and indefinitely. Otherwise, the power to impose such delays would effectively allow prosecutors to send anyone to jail for an arbitrary length of time without trial. So, as much as possible, based on what is mandated under the Republic Act number 8493, the person therefore must be tried in accordance with the number of days and or time set forth by the said law, so that the person will be justified as to what is due to him or due to his counsel during the court hearing or during the court trial in the court arena. The last one or the fourth one is to meet the witnesses to face, to have compulsory process to secure the attendance of witnesses in his behalf. So it means that someone accused of a crime may cross-examine any of the witnesses who testify at trial and applies to statement made in court and statement made outside of court that are offered as evidence during the trial. So this is one of the benefit of the accused, therefore, that he or she has the right to face with the witnesses for that matter, in order to somehow have the or to cross-examine the testimonies and or the accounts made uh, in the court during the trial, and of course made outside the court before the trial is ongoing or before the trial is in the process. The next is the 1973 Philippine Constitution. Based on Article 4 of Section 20 under this Constitution is that no person shall be compelled to be a witness against himself. So meaning a witness shall not be compelled in any proceeding to make disclosures or to give testimony which will tend to incriminate him or make him subject to fines, penalties, and or forfeitures. So let us be reminded that the right against self-incrimination applies only to testimonial compulsion. Ibig sabihin, this will not apply to whenever the accused or the suspect is being invited as the witness, or be invited before the court hearing or trial to be conducted or to be done. Okay. So now let us talk about when the rights of a person against self-incrimination be exercised. So the rights against self-incrimination has two aspects, namely the right to refuse to take the witness stand and also the right to refuse to uh, answer an incriminatory question. So the first is available only to an accused in a criminal case. So meaning to say, this is available only to a criminal case. Thus, an accused cannot be compelled even though a subpoena or court order to testify and be a witness. So meaning to say, the person will not be forced to do or to give his testimony and or any accounts in spite of the subpoena issued by the court and or in spite of the court order issued by the court. The person will not be compelled to give his testimony or to give his accounts that would warrant him to incriminate himself. So example for that, we have the Cabal versus Kapunan case way back December 29, 1962, wherein the right of the accused made available to a person charged administratively for graft because of the nature of the penalty that may be imposed by the administrative body. So the hearing partakes of the nature of a criminal proceedings. So according to this case, so actually the act of the person was being charged administratively, but the hearing partakes of the nature of a criminal proceedings. So, ibig sabihin, even though the person is being charged with the administrative offense of a particular organization and or company, but the hearing partakes of the nature of a criminal proceedings, since this involves criminal acts committed by a particular person under the case of Cabal versus Kapunan. And of course, the second right exercised under which is namely, the right to refuse to answer an incriminatory question is available to both the accused and any witness. So, meaning to say, the person accused and or the witness for that matter has the right to refuse whatever questions that warrants him to give incriminatory answer or incriminatory response to the question during the court trial and or during the court hearing. This is an example of the case of Rosete versus Lim way back in June 8, 2006, that the Supreme Court ruled that this right secures to a witness whether he be a party or not. Okay? So meaning to say it may be a party or the adversary or the prosecution party for that matter. So the right to refuse to uh, the right to refuse to answer any particular incriminatory question, like for example, one the answer to which has a tendency to incriminate him from some crime. So, however, okay, so the right can be claimed only when the specific question, incriminatory in character, is actually put the witness. So, meaning to say, this right will only be claimed by the accused and or the witness whenever the question is incriminatory already that would warrant the witness and or the person to give the incriminatory statement against himself and or herself. So this will only be claimed during the questioning and or during the process of cross-examination and or direct examination, and this will not be claimed on the other time. Meaning to say, if the person is being asked today or this time, this will only be claimed by him or her at this time as well. Okay, so moving on, any person under investigation for the commission of an offense, so this talks about investigation, okay, shall have the right to remain silent and to counsel and to be informed of such right. Meaning to say, in order for the person to be away or to get away with the incriminatory statement against himself, he must therefore be informed of the right to remain silent. Okay, to be initiated by the arresting officer or the officer who is going to conduct custodial investigation, and of course to counsel as well. Meaning to say, to have a counsel preferably of his own choice or be provided thereof. And the second one is no force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Meaning to say, as much as possible, no person be compelled to give his statement just because of the force and or violence, threat, intimidation initiated during the interview or the conduct of custodial investigation initiated by the investigating officer. Otherwise, the statement become inadmissible in evidence in the court proceeding. Okay, so any confusion obtained in violation of this section shall be inadmissible in evidence in any court proceeding. As we believe, the rule of court also applied this principle of the fruit of poisonous tree. Whenever the result obtained is coming from the poisonous tree, and therefore the fruit obtained as well become poisonous itself. Okay, so meaning if the extraction of information is conducted in illegal manner or illegal way, therefore the result of which as well and or the fruit of which as well is illegal or inadmissible. And lastly, as to the transition of the Philippine Constitution, is the 1987 Philippine Constitution based on the Article 3 of Section 12, Paragraph 1, that according to its provision, any person under investigation for the commission of an offense shall have first the right to be informed of his right to remain silent. So this is also cited under the 1973 Philippine Constitution, but these provisions under the paragraph of the Article 3, Section 12 is being capsulized or even more specified as to what it means under which. So, right to be informed of his right to remain silent is that this right may help a person and or the accused avoid making self-incriminating statement or incriminatory statement. So, as much as possible, in order for the accused and or the person being arrested at that time, to avoid any incriminating or incriminatory statement against himself or against herself. Therefore, the police officer has a big responsibility to inform the rights of the accused as to the right to remain silent. And the second one, of course, to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of the counsel, he must be provided with one. This is one of the most crucial rights that the accused must exercise too, most especially during the custodial investigation. Because from there and then, whenever the police officers failed to announce and or pronounce the rights of the accused to counsel of his own choice, and if he is none, meaning to this is that to counsel of his own choice is that he could actually bring his own attorney or counsel and or to call for the counsel or attorney to represent himself to whatever questions to be made by the investigating officer that is subject for the query of the accused counsel or suspect's counsel to verify and or validate if the question is not incriminatory on the part as well of the suspect is to avoid incriminating statement. And if the person cannot afford the services of the counsel, he must be provided with one. Meaning to say, the police or the government for that matter must have this initiative to provide the counsel for the suspect and or the accused to avoid any illegality whenever the police officer will go through with the questioning process in the purpose of getting information or extracting information for that matter. Because whenever the person made a statement that somehow warrant his person as the one who really committed the crime, and or else giving any incriminatory statement against himself might not be used as evidence or as admissible evidence in any court proceeding. Because as what I've said a while back, that the principle of fruit of poisonous tree is being embraced and or applied by the rules of court. So these rights cannot be waived except in writing and in the presence of the counsel. Meaning to say, in general rule, this right cannot be waived. But in some instance, the right will be waived whenever it is with the consent or with the will of the suspect and or the accused to waive such rights. And be reminded as well that the rights will only be waived in the form of writing, meaning to say it must be put into writing an agreement with the presence of the counsel on the counsel of the suspect and or the accused to make any legal means or any legal presentation whenever the accounts and or the statement made by the accused and or the suspect be used as evidence in any court proceeding. Moving on. So the rights of the accused has been constitutionalized in the Philippines. Moreover, it has been recognized by the criminal jurisprudence that should be exercised thereof and be observed by the law enforcement officers and as well as those who are in the criminal justice system. And here it comes, the rights of the accused became more highlighted when the U.S. landmark case Miranda versus Arizona, it is a case wherein in violation to the constitutional rights of the accused. So the rights of the accused of the Philippines has been more highlighted and given importance, most especially when the doctrine of Arizona rights, or I mean the Miranda rights and or the Miranda warning has come into paving its way to make it more adaptive in the Philippine setting. So wherein in this particular case, Miranda versus Arizona, there was an accused named Ernesto Miranda who has been adjudged with charges of kidnapping, rape, and robbery. The said person uh, has been found guilty by the Arizona Supreme Court, but later on the said person, the counsel of this Ernesto Miranda, has appealed the case to the Supreme Court of the U.S. So the U.S. Supreme Court found a constitutional grounds against the investigating officer during custodial interrogation way back in 1960, wherein, according to the findings of the U.S. Supreme Court, led by Chief Justice Earl Warren, that the police officers conducting custodial interrogation were violated the constitutional rights, especially under the Fifth Amendment and in the Sixth Amendment, wherein for more than 2 hours, Ernesto Miranda has been under the custodial interrogation by the two police officers conducting custodial interrogation uh, for the purposes of getting or extracting information based on the crime that Ernesto Miranda was allegedly committed thereto. So, under the Fifth Amendment, based on the ruling of the U.S. Supreme Court, that the police officers violated the Fifth Amendment as to right to refuse to be a witness against himself. Meaning to say, they don't even inform Mr. Miranda as to his constitutional rights uh, to refuse to be a witness against himself, or the right to remain silent in order for him not uh, to make any statement and or accounts that would warrant him uh, to warrant him as the one who committed the crime. And under the Sixth Amendment, the right to an attorney, police officers failed to also announce to Mr. Miranda his rights to have an attorney, because during the custodial investigation, the investigating officers were not observing this right of Mr. Miranda, the right to an attorney. So basically, the U.S. Supreme Court acquit Mr. Miranda of the charges filed by the Arizona Supreme Court, since the investigating officer during that time failed to observe the rights of Ernesto Miranda under the constitutional rights of the accused. So Miranda versus Arizona, in creating the Miranda rights, we take for granted today, reconcile the increasing police powers of the state with the basic rights of individuals. So Miranda remains good law today. So this is also one of the foundations and one of the bases why particular RA or Republic Act number 7438 has been created as part of the laws of the land of the Philippine criminal jurisprudence, so that this would be one of the parameter of the police officers to really observe the right of the accused during custodial investigation, and also be adaptive or to be adapted by uh, the rules of court during the court trial. So let us move on to the next slide. So Republic Act number 7438, an act defining certain rights of person arrested, detained, or under custodial investigation, as well as the duties of arresting, detaining, and investigating officers, and providing penalties for violations thereof. Based on the Section 2 of the RA 7438, rights of persons arrested, detained, or under custodial investigation, and also duties of public officers. First paragraph is that any person arrested, detained, or under custodial investigation shall at all times be assisted by the counsel. So, as more as practicable, and as much as possible, the person being arrested and or detained under the custodial investigation to be conducted by the arresting or by the investigating officer, the arrested person therefore must be exercising his rights, the right to an attorney or to be assisted by any counsel, preferably of his own choice. But based on the protocol that whenever the said arrested, accused, and or the suspect might not able to provide of his own counsel, he will be provided then by the government. And next to that is duties of public officers. So any public officer or employee or anyone acting under his order or his place who arrests or detain or investigates any person for the commission of an offense shall inform the latter in a language known to and understood by him of his rights to remain silent and to have competent. So meaning to say, whenever the particular person will be arrested by the public officer or employee or anyone acting under his order or his place, therefore, the said public officer or employee or law enforcement officer for that matter should announce or inform the particular suspect and or accused of the crime that he has committed with the language or using the language known and understood by him. That is for the purpose of understanding on the part of the suspect and be known to him what are the possible charges and or the cause and or nature of crime that will be filed against him or why he was being arrested. So therefore, he will be given or be read with the rights using the language known to the suspect and or the accused. And independent counsel, of course, preferably of his own choice, who shall at all times be allowed to confer privately with a person arrested, detained, or under custodial investigation. Meaning to say, whoever the counsel of the said suspect and or accused, the suspect has the right to be allowed to confer privately by his counsel with, of course, the things to be discussed in their privacy. If such person cannot afford the services of his own counsel, so that is the thing that I'm talking about a while back, that the person will be provided thereof by the government if he or she unable to provide such attorney and or a counsel. Moving on. Third one is the custodial investigation report shall be reduced to writing by the investigating officer. So it shall be read and adequately explained to him by his counsel or by the assisting counsel provided by the investigating officer in the language or dialect known. So whatever the custodial investigation report taken from the accounts and or testimonies of the suspect and or the accused thereto by the investigating officer should reduce that into writing, and of course it should be signed therefore with the thumb mark, of course, of the person being arrested. Okay, to such arrested or detained person, otherwise such investigation report shall be null and void and of no effect whatsoever. So be reminded that this custodial investigation report is of course being taken with the presence of the counsel, and it must be reduced into writing. It must be signed thereof by the suspect and or the accused, and of course being thumb marked by the arrested person with the presence of his and or her counsel. Fourth one, any extrajudicial confession made by a person arrested, detained, or under custodial investigation shall be in writing and signed by such person in the presence of his counsel or in the latter's absence upon a valid waiver, and in the presence of any of the parents, elders, or in the absence of the counsel of the person being arrested. Any of the person being enumerated and mentioned here are being allowed by the jurisprudence to be a witness of such accounts and or testimony of a particular arrested person. So this will be happening under extrajudicial confession. So when we say extrajudicial confession, it is a confession made outside the court. Most especially, this really happening during the custodial investigation. So otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. So this will be null and or void from the beginning because it has been taken from the illegal means, just because in the absence of proper procedure and or system that should be followed actually by the investigating officer. So that will not be admissible as evidence in court proceeding. Next, fifth one is any waiver by a person arrested or detained under the provisions of Article 125 of the Revised Penal Code. So, what are the provisions under the Article 125? Under the Article 125 of the Revised Penal Code, this pertains to the delay of the delivery of the arrested person to the nearest police station and or to jail or any nearest judicial authority, wherein particular person should be therefore delivered within a certain period of time, being enumerated on that particular provisions of revised penal code, most especially if it is light penalties only within 12 hours, and if it is correctional penalties must be 18 hours, and if it is uh, when it is confirming to afflictive penalties, it must consist up to 36 hours. So if that goes beyond with the number of hours required therefore by the court, of course, the said police officers and or arresting officer shall be subject to administrative case. So since it is being mentioned here, waiver of course shall be in writing and signed by such person in the presence of his counsel. Otherwise, the waiver shall be null and void and of no effect. Meaning to say, if the person arrested waive his right, most especially under the provisions of the article rather of the 125 of the revised penal code, it must be in writing, okay, and signed by such person. And of course, do not forget that it must always be with the presence of his counsel or the counsel provided thereof by your team. Okay, so otherwise, if this will not be followed, the protocol will not be followed, or the procedure, the waiver or such waiver will become null and void and of no effect. Next is that any person arrested or detained or under custodial investigation shall be allowed visits by or conferences with any members of his immediate family, or any medical doctor or priest or religious minister chosen by him or by any member of his immediate family or by his counsel or by any national non-governmental organization. So the person has the right, of course, the person arrested or detained has the right to be visited by any immediate member of his family and or by the council, or allowed by the council and or by the non-governmental organization personnel duly accredited by the Commission on Human Rights. So that talks about the private, the non-governmental organization by any international non-governmental organization duly accredited by the Office of the President. So as used in this act, custodial investigation shall include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed. So without prejudice to the ability of the inviting officer for any violation of law. Meaning to say, the rights of the accused will not only be observed during custodial investigation, but it is also be observed whenever police officers practicing to issue an invitation to a person who is suspected to committed or even participated in the said alleged or commission of crime. So be reminded that whenever the police officers is inviting someone to be interviewed under police custody as part of their investigation of the person to have been suspected of the commission of the crime, the police officer should always observe as well the rights of the persons to be arraigned or to be informed of the right thereof, because otherwise such police officers might be liable for administrative offense of unable to announce or pronounce the rights of the suspect and or the person being invited for an interview, which is under the police custody. Moving on, So a while back, we are talking about the statute of the rights of the accused, which is the RA 7438. But now we will also talk about the Rule 115 of the Rules of Court, rights of the accused. So a while ago, we discussed about the rights of the accused under the constitutions, provision of the constitutions, and a while back, we also discussed it based on the provision of the Republic Act number 7438. But now we will also talk about its rights of the accused under the court proceeding or during the court hearing. So based on the section 1, the rights of the accused at the trial. So in all criminal prosecutions, the accused shall be entitled to the following rights. First, to be presumed innocent until the contrary is proved beyond reasonable doubt. So this has already been discussed a while back from the constitutional right of the accused. To be informed of the nature and cause of the accusation against him, and this is also discussed a while back, that the person or the accused should always be informed with the nature and of course the cause of the accusation against him in order for him that he know really what is the crime being charged against him, and in order for his team and or counsel to be prepared as to what will be going on during the court proceeding and or court trial. To be present and defend in person and by counsel at every stage of the proceedings. So meaning to say, he has the right to be present, of course, to defend himself during or in any stage of the proceeding, and to be assisted always by his counsel from arraignment to promulgation of the judgment. So the accused may, however, waive his presence at the trial pursuant to the stipulation set forth in his tale. So unless his presence is specifically ordered by the court for purposes of identification. So during the arraignment, of course, there must be the presence of the suspect required so by the court to be present therefore for the purpose of arraignment. But in any stage of the proceeding, whenever the counsel opt or allow or therefore give a access or right on the part of the accused not to be present during the proceeding, he might not be present. But whenever his presence is being warranted by the court to be present thereof in any proceeding, therefore he must be present during that time. Next, the absence of the accused without justifiable cause at the trial of which he had notice shall be considered a waiver of his right to be present thereat. So, meaning to say, uh, whenever the reason of the accused not to be present during the proceeding and that warrants of justifiable cause not to be there, that is considered a waiver of his right to be present thereat and should be acknowledged thereof by the court. So when an accused under custody escapes, he shall be deemed to have waived his right to be present on all subsequent trial dates until custody over him is regained. So whatever happened during those stages of trials where he was not being present because he escaped actually, uh, and whenever the custody over him is being regained and therefore he claimed those rights to be present during those stages of trials that he missed up, he will not be given so by it will not be given so by the trying court just because he deemed waive his right during those times because he intentionally and follow his will to escape. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his rights without the assistance of the counsel. So upon motion, whenever there are some discrepancies as to the testimonies and or accounts of the adversary's counsel, upon presentation of the witnesses, therefore the accused will be able to object. Therefore, if he feels or the court feels that the accused is in a better position to defend himself, and it must be overruled by the court or allowed so by the court. Next is to testify as a witness in his own behalf but subject to cross-examination on matters covered by direct examination. So meaning to say, he will be able to testify as a witness on his own behalf, meaning to say he could give any testimony or accounts in his behalf, but of course he will be subject for cross-examination with whatever things and or accounts that he has been given a while back during the direct examination. So his silence shall not any manner prejudice him, meaning to say, whenever he will be asked and therefore did not respond to the question, it doesn't mean that he accept the said accusation. So meaning to say it should not prejudice him. To be exempt from being compelled to be a witness against himself. So whenever there is a uh, question that somehow ruining his image, or that is somewhat going way to or paving way to compelling himself to be a witness or to give an account against himself, he therefore insists not to give accounts and be quiet for that instance. And next is to confront and cross-examine the witnesses against him at the trial. So he has the right to confront and cross-examine by the witnesses against him at the trial by the adverse party. Of course, it will be done by his counsel. Either party may utilize as part of its evidence the testimony of a witness who is deceased out of or cannot with due diligence be found in the Philippines. Okay. To have compulsory process issued to secure the attendance of witnesses, to have speedy, impartial, and public trial, we also discussed that a while back, and to appeal in all cases allowed and in the manner prescribed by law. Okay, so let us continue. Based on Republic Act 8493, the Speedy Trial Act of 1999, as to the legal basis, stages in the process. So there is a duration specified by law under which Speedy Trial Act, years, months, and days. So from the time of filing to arraignment, it must have 30 days. And 30 days also from time of arraignment to first day of trial. 180 days from the first day of trial to termination of trial. And there is 90 days from the termination of trial to the issuance of decision. Meaning to say, this being set forth by this particular statute or law as to the Speedy Trial Act. Therefore, the court must follow the procedure that we're in as to the promulgation of the case charged against particular suspect and or the accused. It must be followed thereto. Denial of right to counsel. Constitutional right of the accused to be heard in his defense by counsel is inviolate, and no court of justice has the power to deprive him of that right. So consequences: absence. So custodial investigation, if judgment of conviction had become final and executory, may still be recalled. If convicted, his conviction will be set aside and a new trial will be undertaken. So meaning to say, if convicted already, and of course, this will be set aside and there will be new trial to be undertaken. So, Court of Appeals resolution dismissing the appellant's brief, so may be recalled. So, ibig sabihin, it will be recalled by the Supreme Court, whatever the decision of the Court of Appeals that somehow dismiss the appellant's application. Gross ignorance of the law and procedure, so reopen to give the accused another chance to present his case. So meaning to say, whenever the accused is not really knowledgeable or have an overview about the case, he will be given a chance. Any statement without assistance of a counsel of his own choice is inadmissible to court, meaning this will not be used against him as to form part of the evidences. So, based on the data being presented a while back, so from the time of the transition of the constitutional rights of the accused from the 1935 up to 1973 and finally up to the 1987 Philippine Constitution, the rights really is being observed. And later on, the government has come to its initiative to come up with making a statute pertaining to the rights of the accused to be observed as well by the attending police officers and or the investigating police officer under custodial investigation, which is talking about the Republic Act number 7438. So under which also is being observed under the rules of court of 115. So as to the analysis, the rights of accused in the Philippines today has been blatantly abused and disrespected, wherein this has been manifested in the context of the campaign against illegal drugs, that there has been near impunity for such violations. Based on the Human Rights Watch report that according to the UN, Statements rather from the highest levels of government had risen to the level of incitement to violence, and vilification of dissent is being increasingly institutionalized. So the report suggests that the human rights institution in the Philippines is marked by an overarching focus on public order and national security, including countering terrorism and illegal drugs, and that this was often at the expense of human rights, due process rights, the rule of law, and accountability. So as to the findings of my discussion, based on the research and report conducted by the Human Rights Watch, that rights of the accused were not observed during the War on Drugs program of the Philippine government that aims to suppress at the end of his term or even will be controlled during the time of his current governance. And also the human rights advocate condemned the said program of the government where it does not follow the protocol in addressing the human rights of the alleged suspects and moreover the rights when under custodial investigation. As recorded, it gave a total of 5,903 alleged suspects were killed along the operation against illegal drugs. On the other hand, rights of the accused are fundamentally constitutionalized, for this will not be waived without the presence of the counsel and or upon the will of the suspects and or accused to waive it during custodial investigation. It has been deliberately observed by the Philippine criminal jurisprudence to serve the accused with just and fair treatment during the court proceeding and the right of to exercise their rights whenever it calls the attention for the defense in their person. Moreover, landmark case decision by the U.S. Supreme Court Justice Miranda versus Arizona had made it to pave the way as the prototype in observing and in exercising the rights of the accused during custodial investigation, in which such landmark case has been adopted not in the Philippines alone, but for the other part of the world which has the same criminal justice system as of the U.S. Conclusion. Therefore, the rights of the accused must be upheld with dignity and respect by those who are in the authority, most especially the implementing agency of the criminal laws and or statutes. The law enforcement personnel, for that matter, must be indoctrinated with how important and to give value on the existing law that protects the rights of the accused and must apply, therefore, of what was mandated on the Constitution for the accused's constitutional rights. However, on the other hand, accused must be aware of such rights and therefore must not be denied before him by the arresting or inviting officer. And as much as the court proceeding is concerned, the right of the accused must also be observed and therefore be given with fair treatment with others and be heard before the court condemned. So, on the other hand, must always conform the mandates of the Speedy Trial Act to serve rightfully the accused with due time to render its decision over the subject matter of the person accused. Recommendation. On the custodial investigation, investigating officer, law enforcement officers must be instructed and trained to respect the right of the accused to remain silent, to counsel of his own choice, and be informed of the nature and cause of the arrest in a manner that is consistent with the respect for the right guaranteed in the Philippine Constitution and by the Republic Act No. 74/38. Any law enforcement officer who violates the right of the accused should be held accountable and victims of violation should have the right to an effective remedy and redress. On the court proceeding, the prosecuting judge of the competent court must look into the possible remedies for the period of trial as required under the Republic Act No. 8493 known as Speedy Trial Act. So the following is my bibliography as to the conduct of my research and study for this particular topic. Alright, so thank you for listening with my discussion. Thank you, Sir Marjun, for this opportunity to give my insight and or discussion on this particular topic about the rights of the accused. God bless to everyone and God bless to you, sir.